Don't trip over supplemental jurisdiction. All right, what's our rule? Supplemental jurisdiction. The district court may exercise its discretion to include claims that arise from a common nucleus of operative fact, such that they are part of the same case or controversy. Repeat, the court may exercise its supplemental jurisdiction over claims that arise from a common nucleus of operative fact, such that they form part of the same case or controversy. Let's repeat that one more time. A district court may exercise its discretion to include claims that arise from a common nucleus of operative fact, such that they are essentially part of the same case or controversy. So our three prongs are discretion, claims that arise from a common nucleus of operative fact, and are essentially part of the same case or controversy. However, we want to not trip. When does supplemental jurisdiction apply to the piggyback claim? 3 scenarios. 1, compulsory counterclaim, same transaction or occurrence. What's our legal standard? So related that the claims become part of the same case or controversy. So compulsory counterclaims arise from the same transaction or a common nucleus of operative fact. They can always be brought, and in fact, they must be brought. Otherwise, they are precluded. Does the counterclaim have to have the amount in controversy? No. Remember, don't trip. The plaintiff cannot bring claims that destroy diversity, but the defendant may bring claims that destroy diversity. All right, supplemental jurisdiction applies to compulsory counterclaims by the defendant. 2, impleading third-party defendants for indemnification or contribution. Impleading third-party defendants for indemnification or contribution. And just as an aside, the 100-mile a bulge rule only applies to impleading third-party defendants. And multiple plaintiffs, actually, we're not going to cover that. When does supplemental jurisdiction not apply? Not apply. Okay, well, we just said that a defendant may join plaintiffs that destroy diversity, but the plaintiff can't. So watch out, don't trip. Plaintiffs may not implead or join a defendant who destroys diversity in a diversity case. This is our don't trip. Don't trip. Plaintiffs may not implead or join a defendant who destroys diversity in a diversity case. What about a federal question case? It doesn't matter. Doesn't matter. Okay, permissive counterclaims, we know they must have, that's right, an independent basis for subject matter jurisdiction because they're not the same transaction or occurrence. So therefore, must they meet the amount in controversy? Yes, because they must have an independent basis for subject matter jurisdiction. If it's a permissive counterclaim, it's not related. So the claim has to meet the amount in controversy or there is no SMJ. All right. When does this matter? Diversity. When does it not matter? Federal question. Okay, watch out. Don't trip. If you're in court based on federal question, we don't care about diversity. Are we in court on federal question? We don't have to worry about amount in controversy. When does subject matter jurisdiction not apply to that, quote, piggyback claim? If a plaintiff tries to implead a defendant or join a defendant who destroys diversity in a diversity case, if we're in court based on diversity, the defendant can't make a permissive counterclaim because a permissive counterclaim must have a independent basis for subject matter's jurisdiction. So it must meet the amount in controversy. Okay, 3 is changes to the lineup of the parties post-filing. Remember, the case is commenced when the action is filed. Okay, so this only happens in one instance. First of all, we start out with diversity. Plaintiff 1 is from state A, plaintiff 2 is from state B, the defendant is from state B. Yikes, do we have diversity at the time of filing? No. But what if plaintiff 2 from state B, the state B plaintiff voluntarily dismisses? We have diversity. Diversity will be saved. Diversity will be saved if the non-diverse plaintiff voluntarily dismisses. And that's it. What's our rule for supplemental jurisdiction? The district court may exercise its discretion to include claims that arise from a common nucleus of operative fact, such that they are part of the same case or controversy. That's it.